as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made. Do you share the view that in the absence of declarations in the terms of Article 2, Clause 2, this judgment is a brutum fulmen? It's an empty judgment. Do you share that view?
Not at all. I don't think it's a brutum fulmen. I think it's unusual that the Supreme Court typically would have given a judgment without an order, because the order is perfect and complete judgments. But it's not brutum fulmen. If you look at the Constitution under Article 1, Clause 2, it says anything done inconsistent with the Constitution is void. Therefore, where there's a declaration of anything having been done in violation of the Constitution, the declaration essentially is saying that that act is void. So even if it is not capped with a consequential order, under the principle of what we call in constitutional law, nullification impairment, the statement of nullification that makes it void impairs any action against the void conduct. So even without a consequential order, you are not supposed to act pursuant to the void order. So the principle of nullification impairment deals with that. It doesn't have to be capped with an additional order for a particular conduct in one direction or the other.
Right.
The fact that you've been told that you're doing it wrong implies that the act has been nullified and your further conduct in that respect has been impaired. However, it remains.
Is there a problem to the effect that there's no order or direction at the Speaker or the Parliament? The Speaker was the first defendant, though.
Not at all. That's the point I'm making about the nullification impairment. But it's important to put this in context. I think one thing that lots of people haven't realized, that the Speaker really did not make any orders for purposes of him being injuncted and therefore for purposes of him being given orders. In other words, the Speaker made a declaration of a status quo. What the Speaker did was to declare that seats have become vacant pursuant to Article 97. So he simply declared the status quo per the Constitution. When someone makes such a declaration, you only need a counter declaration to stop that particular declaration. You don't need an order, because to stop the Speaker will be to stop him from doing nothing. He hasn't done anything. He hasn't put armed policemen at the entrance of Parliament, preventing these members of Parliament from taking their seats. He hasn't made an order for their names to be struck from the register, for example, of Parliament, or the Hansard. He hasn't made specific orders of things that should be done, which should have been reversed per order. What the Speaker did was to make a declaration. So the Speaker's conduct was declaratory. Therefore, a counter declaration solves the problem. He doesn't need to be directed to do any specific thing because he hasn't even done anything. And that's why when I hear arguments about contempt, I wonder, what is the Speaker going to be held in contempt of? Because he hasn't really done anything. All he did was to make a declaration of a status quo. It is the members of Parliament, NDC and MPP members of Parliament, who have been squabbling on the question of majority and minority seats and who does what pursuant to the Speaker's declaration. So the Speaker himself did nothing. He only made a declaration which has generated a furore. And so making an order against him rather would be the order brutal for me, if you ask.
Do you share the view, and this will be my last question to you, that maybe last but one, because we come to jurisdiction, which I want you to be brief about. Do you share the view that this particular statement in the lead judgment is the reason no orders were made, so to speak, and that this is seeking to say that if you want to get orders specific, you should rather go to the High Court? It says that the suit essentially hinges on a pure question of law, specifically the proper construction of Article 97(1) G and H, to establish the legal threshold for triggering its provisions without delving into factual disputes regarding seat vacation in Parliament. Please note that it is to make the interpretive job without delving into the factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. Accordingly, to the extent that the exclusive preserve to settle a matter of interpretation under Article 2.1 and Article 131 and 2 lies with the Supreme Court, it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. Make note of that. To resolve the interpretation for the application of the High Court. The decision of this court in ex parte Zanator 1 cited supra refers. Let's hear you.
Well, I can't tell whether that's the reason orders were not given, consequential orders were not given. But as I indicated, the lack of consequential orders in this case, frankly, for me, is not fatal. It's a declaration of unconstitutionality is enough to address the void nature of any order or action, and therefore it addresses that. The question of jurisdiction, however, is more difficult for me to accept, and I would have wished that the court had actually ceded jurisdiction to the higher courts. Now, I'll tell you this the reason. The Constitution is structured to respond to specific needs, and the clarity of the Constitution in terms of separating things cannot be ignored. The determination of the petition on who the president of Ghana is, presidential petition, is left to the Supreme Court. The determination of the parliamentary election, any petition for parliamentary election, is left to the High Court. What the Constitution framers sought to do was to create a bifurcated arrangement in which the Supreme Court is in charge of things presidentially, and then the High Court is in charge of things parliamentarily, so to speak. This cannot be mistaken. And I think that the reason for that is that the framers intended that the Supreme Court should not be overburdened unnecessarily by the 200 and something people who have been elected. And since we have one High Court scattered across the country, and there are different High Courts closer to different constituencies, let's leave parliamentary business or the decision of who has been elected to Parliament. Let's leave it to the High Court. Now, if you look at the framing of Article 97, which you read earlier, Article 97 contains an implicit interpretation. So even though the Supreme Court has exclusive jurisdiction, under the rules of interpretation, which all lawyers or law students are taught in law school, the principle of the generalia specialibus principle, where you have a specialized provision dedicated to a particular entity, and then there is a derogated general provision, the law says the special provision reigns. So even though Article 130 and Article 1+2 gives the Supreme Court exclusive jurisdiction in constitutional matters, Article 99 specifically vests the High Court with just that small specialized area of dealing with matters concerning Parliament, so that even if they do contain some collateral aspects of interpretation, the Constitution has given that to the High Court. And if you look at the provision, it says the determination of whether there has been a vacancy. There cannot be a determination without implicit interpretive matters that are collateral to that determination process. And those implicit collateral determination matters are not derogate, they do not derogate from the overall Supreme Court mandate of exercising authority in terms of the interpretation of the Constitution. So I think that when it came to the question of
Prof. Abotsi, once again, don't you see that in the portion I have read to you, there appears to be a concession to what you are just saying? They say that this suit essentially hinges on a pure question of law, specifically the proper construction of Article 97, 1G and H, to establish the legal threshold for triggering its provisions without delving into factual disputes regarding seat vacation in Parliament, which properly lies within the High Court's purview under Article 99 of the Constitution. And they proceed to say that they will do this, and they said that it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court. Is that a concession?
Well, I mean, you can give that concession that the Supreme Court is trying to clarify things. The Supreme Court is trying to bring some clarity on how the High Court should exercise its jurisdiction. If that is the intent, which we can glean from the judgment, then it's not a bad intent, to the extent that the High Court will now be better equipped to exercise its Article 99 jurisdiction. I would have rather expected that perhaps the Supreme Court could have assumed jurisdiction in terms of the scope of Article 99 for the High Court to exercise. But that is not the question before it. And therefore, it couldn't possibly go into that.
So that this will mean, Prof,
or could have gone.
Prof, so that this will mean that the Supreme Court is saying, now we have interpreted this provision. So you can always go to the High Court to apply it. And the High Court cannot apply it differently to determine whether there's a vacancy or there's no vacancy. They will be guided by the decision we have made. Is that not what they are saying?
Right, and that's the point I'm making, that with that intent in mind, it's not a bad intent. It's a good intent. It's almost like the court saying, look, we are going the extra mile of clarifying a position. Moving forward, the High Court is equipped. I think the only difficulty, as I indicated earlier, is that even in that, I did not see the full scope of determination of the circumstances of how a vacancy occurs. I think that the court could have probably given us much more indications of the various circumstances. I think it's still a bit too general, and that's why I worry about the future.
Thank you very much, Prof. Abotsi. And this is where we'll end this discussion with Prof. Abotsi. We'll take a break. We'll